The gavel hadn't even cooled, yet the headline detonated across America. In a single, brutal instant, the illusion shattered. An emergency court bid, thrown like a last-life raft, didn't just fail. It collapsed. Hard. The kind of loss that doesn't invite spin or delay, the kind that lands with a thud and leaves no room to breathe. For years, the promise of immunity had loomed like an invisible shield, untouchable, unquestioned, almost mythical. And then, suddenly, it wasn't. This wasn't a slow leak. This was a rupture. News alert screamed. Screens refreshed. Commentators froze mid-sentence, realizing they were watching something rare. Power meeting a hard boundary. The emergency appeal was supposed to stop the clock, to buy time, to preserve the idea that some figures move above the law, not through it. Instead, the clock kept ticking, louder than ever. Across the country, people felt it before they fully understood it. A collective jolt. The sense that a door long slammed shut had cracked open, just enough to let reality rush in. Supporters scrambled for explanations. Critics blinked, stunned by the speed of it all. No dramatic hearing. No extended showdown. Just a ruling that landed fast, clean, and devastating. For those who have spent their lives being told the rules apply differently depending on your name, your accent, your birthplace, this moment hit deeper. It felt personal. It felt overdue. Because immunity, in its ugliest form, has always been a privilege masquerading as principle. And tonight, that privilege took a visible hit. What made this moment so unsettling wasn't just the loss. It was the finality. The word emergency implies urgency, desperation, a belief that the system will bend if pushed hard enough. This time, it didn't. The system stood still, unmoved by bluster or threat. And as the first reactions poured in, one truth became impossible to ignore. This wasn't noise. This wasn't theater. Something foundational had shifted. This ruling didn't land in a vacuum. It struck at the very last emergency firewall Donald Trump had left. Not a policy defense. Not a political rally. But immunity itself, the argument that time, power, and position could still outrun consequence. This was the line drawn to stop everything else from crashing forward. And when it failed, it didn't just weaken a case. It rewrote the battlefield. For years, lawsuits had come and gone, each one framed as survivable, delayable, manageable. But this was different. This was not about whether Trump would eventually face accountability. It was about whether he could stop the clock at all. The emergency appeal wasn't strategy. It was desperation. A final attempt to freeze legal reality before it collided with political momentum, campaign timelines, and public reckoning. Because time, in this moment, is the true enemy. Every week that passes narrows options. Every ruling accelerates consequences. The court understood that. And so did Trump. That's why this wasn't just another filing buried in legal archives. This was a race against the calendar, against voters, against history itself. Lose here, and the narrative shifts from dominance to defense. At stake wasn't only one man's legal exposure. It was the scope of executive power. The idea that the presidency could act as armor long after the office was left. If immunity held, it would confirm a dangerous precedent, that the highest seat in the country could permanently elevate someone above the law. If it fell, it would reaffirm something older, quieter, and far more radical, the principle that no title outlives accountability. That's why this moment reverberated beyond Trump's orbit. Judges weren't just weighing arguments. They were weighing the future boundaries of power. How much deference is too much? How far does authority extend once the applause fades? These questions don't live in textbooks alone. Donald Trump did not stumble into the belief that consequences were optional. That belief was built, reinforced, and rewarded over decades. Long before courtrooms became central to a story, escape itself became the pattern. Lawsuits ended in settlements. Investigations dissolved into delays. Deadlines stretched. Technicalities appeared at just the right moment. Again and again, the system blinked first, and each time it did, the myth grew stronger. The lesson was simple and seductive. If you push hard enough, long enough, accountability gets tired. Paperwork overwhelms truth. Complexity buries responsibility. For Trump, this wasn't failure avoidance. It was strategy, a way of turning time into a weapon and exhaustion into leverage. The goal was never to prove innocence. It was to make consequences impractical. Over time, that pattern hardened into identity. Trump didn't just survive scandals, he narrated them as victories. Every escape was proof of genius. Every delay was reframed as dominance. Losses became conspiracies. Scrutiny became persecution. And slowly, a political persona emerged that fused personal grievance with public power. He wasn't just untouchable, he claimed. He was targeted precisely because he was strong. This is where grievance politics took root. Trump positioned himself as both conqueror and victim, a man powerful enough to command crowds yet perpetually wronged by shadowy forces. Courts, journalists, regulators, immigrants, elections themselves all became characters in a single story where accountability was recast as injustice. If he was questioned, the system was corrupt. If he was charged, democracy was under attack. The contradictions sat in plain sight. Trump argued for absolute authority while demanding endless sympathy. He claimed total control, yet insisted he was helpless against institutions. Power, in this worldview, only flowed one direction: downward, never inward, never back. The courts do not shout. They do not posture for cameras or measure their power in applause. They move slowly, deliberately, almost frustratingly so. And that is by design. While politics thrives on urgency and emotion, the judiciary was built for endurance. Its strength has never been spectacle. Its strength is patience. For decades, the machinery of law has operated in the background of American life, unnoticed until it is tested. Judges are trained to distrust haste, to resist pressure, to separate noise from substance. They inherit a tradition that values restraint over reaction, precedent over personality. Every ruling sits atop layers of history, arguments once made, boundaries once defined, mistakes once corrected. Nothing arrives in isolation. This is why the courts feel boring to those addicted to chaos. Legal reasoning does not trend. It does not chant. It does not bend simply because a moment feels loud or urgent. Instead, it asks a quieter question: what happens if this power goes unchecked tomorrow? The judiciary exists to answer not for the present crowd, but for the future citizen who has no microphone. The Constitution itself was written with this fear in mind. Power, the framers believed, expands naturally. It needs friction, limits, guardrails that do not depend on the character of whoever happens to be in charge. Courts are one of those guardrails, designed not to dominate government, but to slow it down when momentum threatens to outrun principle. Judges live inside that responsibility every day. They do not get to choose the moments that define them. The moments choose them. An emergency filing lands on a desk, stripped of rhetoric and urgency, reduced to claims and consequences. The task is not to decide what feels fair in the moment, but what remains defensible when the moment has passed. This is the unglamorous heroism of the judiciary. By the time the emergency filing reached the court, the confidence sounded rehearsed. Polished language, absolute claims, assurances delivered as if inevitability itself were on their side. But beneath the surface, the urgency told a different story. This was not a strategic move planned months in advance. This was a sprint, fueled by shrinking options and an accelerating clock. Emergency appeals exist for one reason: to stop something irreversible from happening. Trump's legal team framed their request exactly that way, warning of catastrophic consequences if the court failed to intervene immediately. They spoke of unprecedented danger, of chaos unleashed, of a presidency retroactively crippled. The tone was forceful, but the timing betrayed them. You don't ask for emergency relief unless you believe control is slipping. Behind the scenes, everything pointed to compression. Arguments were condensed. Risks were bundled. Legal theory was stretched to its outer limits. There was no room left for delay, no procedural maze left to wander. This was an all-or-nothing play, designed to force the court's hand before momentum became impossible to reverse. That pressure seeped into the language itself. The filing leaned heavily on broad assertions, sweeping claims about executive authority, warnings that felt more political than constitutional. Immunity was no longer defended as a narrow protection tied to specific duties. It was presented as a necessary shield against accountability altogether. And that shift mattered. Courts listen carefully when arguments change shape under stress. Judges are trained to notice when reasoning expands suddenly, when precedent is cited selectively, when fear replaces structure. During questioning, those seams began to show. What exactly was the harm being prevented? Why did accountability itself require an emergency pause? If immunity was so absolute, why did it need saving at the last possible second? The ruling arrived without theatrics, but its weight was unmistakable.
No fireworks. No grandstanding.
Just language, calm, deliberate, unflinching, cutting through years of assumption. The court did not shout. It stated. And in doing so, it dismantled the idea that immunity could float free from limits. The judges began where power always meets its test: scope. Authority, they made clear, is not a blank check. It is granted for specific purposes, bounded by law, and answerable to review. The presidency confers immense responsibility, but responsibility is not exemption. The ruling walked carefully through that distinction, refusing to inflate title into license. Power, the court reminded, exists within a system, not above it. There was a moment, almost imperceptible, where the argument lost oxygen. Trump's claim depended on absolutes. Absolute immunity. Absolute protection. Absolute deference. The court answered with conditions. Context. Consequence. Each paragraph narrowed the space where immunity could hide. What actions were being shielded?
Why?
At whose expense? These were not rhetorical questions. They demanded answers the argument could not supply. Silence followed those lines. The kind that settles when certainty evaporates. In that silence, it became clear this ruling was not interested in personalities. It was interested in principles. The judges acknowledged the weight of the office, then drew the boundary anyway. The office matters. The office does not erase law. The court rejected the premise that accountability itself constitutes harm. Once spoken plainly, that idea collapsed under its own logic. If being questioned is damage, then power can never be examined. If review is injury, democracy becomes decoration. The ruling refused that inversion. Accountability was not framed as an attack on governance, but as its safeguard. What followed was a methodical dismantling of the emergency narrative. The judges addressed urgency without being ruled by it. The reaction was instant, relentless, and impossible to contain. Before analysts finished reading the ruling, the country was already arguing about it. Social media lit up like a power grid hit by lightning. Legal scholars began threading explanations in real time, breaking down the language, underlining phrases, circling sentences that would echo for years. Commentators who had spent months hedging suddenly spoke with clarity. This was not ambiguous. This was not routine. This was seismic. Clips spread faster than context. Headlines sharpened by the minute. Some called it overdue. Others called it dangerous. But almost everyone called it historic. The ruling cut through the usual fog because it did something rare. It surprised both sides. Supporters of Trump scrambled to soften the blow, insisting it was temporary, procedural, misunderstood. Critics sensed something different. Not victory exactly, but momentum. The kind that changes behavior. Allies moved quickly into damage control. Statements were released emphasizing resilience, framing the loss as a minor setback, a misunderstanding soon to be corrected. Surrogates went on air insisting nothing fundamental had changed. But their language betrayed urgency. The certainty that once defined the narrative had fractured. Confidence sounded thinner. Defiance felt forced. Meanwhile, critics didn't celebrate. They leaned in. They understood what this moment represented. A crack, not a collapse. An opening, not an ending. Prosecutors, advocates, and watchdogs read the ruling not as a conclusion, but as permission. A signal that arguments once dismissed as unthinkable were now viable. That walls long assumed permanent might, under pressure, give way. Legal circles felt it first. Texts flew between attorneys parsing implications. Could this reasoning apply elsewhere? Would other courts follow? What did this mean for pending cases waiting just beyond the horizon? In the wake of the chaos, one truth stood out with quiet force. This was not a partisan victory. It was a victory for the idea that no one, no matter how loud, how powerful, or how feared, is above the law. The headlines screamed conflict, but the ruling itself whispered a principle far older and far steadier than any political debate. Accountability endures where spectacle cannot. It reminded the nation that systems, built over decades, are designed not to celebrate dominance, but to safeguard fairness. For a moment, the noise of rallies, tweets, and hashtags faded beneath the weight of clarity. Courts, those unassuming institutions often overlooked or misunderstood, had done exactly what they were meant to do. They had not bowed to pressure, they had not flinched at fame, and they had not confused volume with legitimacy. Calm reasoning prevailed over brash assertion. Methodical truth outlasted bluster. The machinery of law, unglamorous and meticulous, had proven that restraint is a form of power itself. This is the lesson that extends beyond politics. It is a lesson about character, about responsibility, about dignity. Power does not grant immunity. Influence does not erase consequence. Titles do not erase obligation. What matters is how one meets limits, how one responds to scrutiny, and whether one accepts accountability as a companion rather than an adversary. This ruling, in its quiet decisiveness, underscored that principle. Character outlasts command, and respect for rules defines enduring authority more than any display of strength. For communities long subjected to inequity, this moment carried profound meaning. For immigrant families, for those whose voices are often ignored, the ruling was validation. It was a reminder that law, at its best, can operate as a great equalizer. That institutions, while imperfect, are capable of protecting the vulnerable, restraining excess, and maintaining integrity. Trump's immunity didn't just crack, it collapsed. The last shield, the final firewall that once seemed untouchable, has been tested and found insufficient. What happened in that courtroom was more than a legal decision. It was a statement about limits, responsibility, and the enduring strength of democratic institutions. The message is clear. No person, no matter how powerful, can operate beyond accountability forever. This ruling carries historical weight. It reminds us that principles matter more than personalities, that restraint and reason can prevail over bluster and entitlement, that dignity, fairness, and equality under the law are not abstract ideals. They are enforceable, observable, and defendable. For the first time in a long while, the system flexed in a way that reaffirmed the values we all depend on. This isn't about politics as usual. This is about justice asserting itself, slowly, patiently, and decisively. And the story doesn't end here. The consequences of this ruling will ripple across courtrooms, campaigns, and institutions. What happens next depends on us, on the public who watches, shares, and insists on accountability. The chapter is still unfolding, and staying informed matters more than ever. If this moment resonates with you, share the story. Let others see that power is not absolute, that accountability exists, and that institutions can hold firm when we demand it. Subscribe to follow the unfolding narrative of accountability, courage, and principle in action. Engage with the discussion, because the lessons of this case will shape the future of leadership, law, and democracy itself. Stay alert, stay informed, and remember, when power meets principle, the story is never truly over, and history is always watching.